of the university, ma'am, Professor Dr. Padmakali Banerjee, for providing us this encouragement and the opportunity to organize such sessions where our students can learn through gaining this information by sharing the thoughts with experts from the industry. I express my thanks to Professor Sadanand Prusti, also our provost of the university, the Dean for the School of Management, and the convener of the institution's Innovation Council, SPSU. Now, in the series of events that we've been organizing on the banner of IIC, today we have a webinar on the topic Intellectual Property Rights and its significance in research and innovation. And we are delighted to welcome our guest speaker, Dr. Prachi Chopra, who has been extremely kind and accommodating in accepting our request to interact with our students today. So it would be my duty and my pleasure to introduce our distinguished guest to you. Dr. Prachi Chopra is a versatile personality with many talents. She is a young dynamic entrepreneur, an award-winning entrepreneur. She is a researcher, an IPR trainer, an excellent orator, advisor, mentor, professor, YouTuber, and IPR facilitator. She is a qualified BTech and MTech and a PhD in electronics and communication. She has over 10 years of academic and industry experience. She is the founder and director of a company called Intellect Bastion LLP. Presently, she is the president of the Delhi Innovation Council of Women's Indian Chamber of Commerce and Industry. Her achievements include being the mentor of change in the Atal Innovation Mission. She is the expert reviewer with Academic Exchange Information Center. Now, this is a strategic partner in world-leading publication houses, including IEEE, Springer, Elsevier, Willis, etc. She is the Indian Achievers 2021 award-winning entrepreneur, a global ambassador for Women Tech Network, member of many technical committees meant for conferences and seminars in IPR committees, and she is a qualified GATE in 2012 with 98.8 percentile among her many achievements. She has numerous publications in international and national journals, has participated in various development and training programs. Her technical subject expertise includes digital signal processing, artificial intelligence and machine learning, communication system, etc. And her research interests are signal and image processing, iris recognition, biometrics-based optimization algorithms, age, gender, and race estimation using biometric techniques, and much, much, much more. Ma'am, it's been my pleasure to read your introduction and have you amidst us today. Many thanks for being here. And now, without delaying a single moment, I hand it over to you. Welcome once again.
Thank you so much, ma'am. Yeah.
Congratulations, ma'am, and welcome to SPSU. And in this platform of this webinar on the IPR. Okay, so really we'll be thankful to you that you have at least accepted our invitation and agreed that we will be delivering this session for our students and also our faculty members and the outside institutes, faculty and the students. And many thanks to Professor Anand, that who is the coordinator. That means he only arranged this particular webinar. That means on the IPR. So thanks to Professor Anand. Thank you, ma'am. Thank you, ma'am.
So thank you so much for all of you for such a warm welcome. I'm really honored, and I'm really happy to be a part of this conversation regarding IPR, intellectual property rights. This is, students, faculties, researchers, really need some awareness on this topic, because I have seen that in institutions and universities, students and faculties are, even not aware of the terms, what are patents and how is patent different from IP. Some people get confused between the two words patents and IP. Say they patents, we call it either patents or IP, but IP, it's a complete term in which we have some different types of intellectual property rights like patents, trademarks, copyrights, designs, trade secrets. So it is all these all are included under the umbrella of IPR. So there is a need to have an understanding regarding this, awareness regarding this, that what is your research area and how you can protect that research, you can commercialize that research, you can use that research for your career growth and business decisions by protecting it through different types of IPs, under which IP your kind of research work, your creativity can fall into. It falls into patents or trademarks or copyrights or designs. Firstly, we need to understand the definition, the practical concepts regarding different types of IP. That, then only we will be able to analyze that which IP is suitable for us. So that's why this topic is really important. We need to understand this. That's why is the topic, which is IPR and its significance in research and innovation. I just want to firstly know from Disha ma'am can in fact tell that these all who are in this conversation are all faculties or students. I just want to know so that I can have my discussion accordingly.
Both, ma'am, faculty as well as student, both are present here.
Okay, both faculties and students are present there. Here, that's great. So, fine. I'll share my presentation now. Let me know if it is visible to you. Yeah, so is it visible on the screen?
Yeah.
Yes, ma'am. Visible.
Yes, completely.
IPR and its significance in research and innovation. My name is Dr. Prachi Chopra, as already introduced. There is no need to introduce it further. Let's come to the line of today's presentation, that we will be discussing about what exactly is IPR, intellectual property rights, an introduction to the term, to know what exactly it is. Then we will come to different types of IPR. There are so many kinds of intellectual property rights that we need to understand. We need to digest that what kind of IPR is suitable for what kind of research and innovative work. That is to be understood. Then third is importance of IPR in research and innovation, and indirectly in business aspects and commercialization in startups. As an entrepreneur, what is the importance of IPR? Why we need IPR? So importance is very important topic which we need to discuss. That why it is important in research and innovation. So let's come to the topic, which is introduction to intellectual property rights. See, we need to understand two terms, intellectual property, and then we will come to intellectual property rights. Intellectual property, as the name suggests, intellectual, which comes out of your mind, which is created out of your mind, which is created by your mind. Anything which is a creation of mind, your mind, anyone else's mind, but anything which is created by your intellect, that is your intellectual property. Like physically, if I talk about property, any tangible property rights you have for that property, you can you sell that property, rent out that property, and you can earn revenue and money out of it. Similar is another type of property, which is a creativity of your mind as a part of your intellect. That may be some invention. Through your thought process, you may have come up with some idea and an invention out of it, or some artistic work like painting, some new creative artwork, or some literary work like books, novels, or maybe some research papers like which you write out. So these literary works, artistic works, or inventions are some, what we call, under what umbrella these types of things come into, which are created by your mind. These are your thoughts which invent these things, that invents. So this type of property which you own, which is created by your mind, through your thought process, through your intelligence, through your observations, through your hard work, that is intellectual property. So one of that intellectual property, if I talk about institutions and universities, is your research work, R&D work, and when you come up with a product or a process or a system, some composition. If I talk about pharma department, pharmaceutical department, so these compositions or something, some new formula you have come up with. So these types of inventions, as a part of as a student, as a part of an institution, when you do so much R&D in labs and come up with such inventions, this is your intellectual property. You need to protect that, because in future you can make money out of that. So the agenda here is this: to protect the work which you have done in your name, so that you can use it for your commercial purposes, or maybe you can have it in your name for your resume, for your professional growth. Purpose may be anything, but you need to protect it so that no one copies it without your consent. So how to protect it? Protect it through intellectual property rights. So these are the property rights that you as an owner, as a creator, as an inventor, would like to own, and government gives you this right. When you disclose to the government the whole invention in terms of working, construction, drawings, everything which is required for any other person to develop it on their own, and in return, government gives you an exclusive legal right in the form of a certificate that for another 20 years or 10 years, whatever is the deadline of that right, for a prescribed time period, you can exclude others from making, using, selling, importing your invention without their consent, unless and until they take it as a license or you sell them. They will not be able to do anything with your invention without your approval. So that is the right you can simply compare it. It's similar to any other property right, physical property right, but here the property is non-tangible. In any physical property, like a house or something like that, it's it's visible in the form of, a touchable item. But here this is something created out of your mind, which you own as a legal document. You can use it for your purposes. You can exclude others from making, using, selling, importing, or offering for sale without your consent, and hence you can make business out of it. So that's the whole purpose here. This is what is intellectual property rights. I hope this is clear. If still there is any question, you can ask in the end of the at the end of the presentation. Now, why to promote and protect intellectual property rights? This is a very obvious question. When we come to understand, when we understand the whole definition of intellectual property rights, it becomes very easy for us to understand why to promote and protect. Obviously, why will you put in so much hard work in the form of financial, physical, mental drainage, and 3 and 4 years of R&D? Why will you put in so much hard work when you know that someone can come after 3 to 4 years, having seen your product, they can use it for making money out of it? You would like to have that benefit, and you would obviously would want to, exclude others from having that benefit, because this is what you have done, and you have put in so much financial, mental, physical time. You have devoted so much for this invention. So if you are not given any right for that work, you will not be motivated. So for motivation, this right is provided to inventors and creators, so that inventors and creators are motivated to do more and more R&D to, increase the global innovation index of India, which is very less right now presently, but government is motivating intellectual property now. So it's increasing. Technology cannot grow without intellectual property rights. It's very obvious. So secondly, the progress and well-being of humanity rests on its capacity to create and invent new works. When we create new works, no, when we create something, it decreases the competition for you. Yes, indeed, but it motivates others to improvise it. They know now that this is the work which has been done until now. Now this becomes the prior art. Now well-being of humanity rests on this, because you will be, others will be progressive enough to work on your invention as a base and come up with more improvements over it. So how will technology grow until they have some work which is already done as prior arts? So that's why we grow as a community, as a technology and culture grows, when we all come up with the improvements on each other's works. So that's why protection of intellectual property rights, intellectual property is important. Thirdly, when you have an intellectual property, you have a product which you own, you can create business out of it, and that in turn spurs economic growth, creates new jobs, because a new business is created. New business can be created by even a single product. So this creates new jobs. This enhances the quality and enjoyment of life. Economically, a country grows. So this is how this promotes the whole innovation growth of a country. And personally and as a community, we also grow. We personally also grow, and as a community also grow. Nationally, we also grow. So that's the importance of intellectual property rights. Now, there are different types of intellectual property rights. The main types of intellectual property rights. There are 6 types of intellectual property rights which are mainly known and mainly used. First is patents, then industrial designs, which we popularly know as design patents. Third is trademarks, then copyrights, then geographical indications and trade secrets. The first 4 are very well known. The 5th and 6th are known somewhere, or these are not that much popular as are the first 4. So let's discuss them one by one to understand. While I'll be discussing, you can just compare the work in the back of the mind. You can analyze that the work which you are doing, under which type of IP rights it comes. So patents. See, patents, the word which under, when it comes to patents, patents protect innovations, technical works, any technical solution to a problem. Maybe in pharma sector, or maybe by a student or a researcher from the engineering side. If you have done some technical improvement, functional improvement, that designs a new product or process or a system or a composition or a machine, anything like that, and you either improvise it or you create a new product or a process. So if technical advancement is done, some inventive work is done, that grows, that is, that adds some technical advancement, or economically it grows. It helps in some growth. So that kind of work is protected by an exclusive right, which is granted by patents. Clear? So patent is granted for any product or a process or a machine or a composition or things like systems, such works which helps in technical advancement, provide technical solution to a problem. Patents provides exclusive monopoly to you. In what way? That you can stop others from making, using, distributing, like importing, selling, offering for sale, your work, which is your product on which you have a patent right without your consent. So you can provide consent by licensing them, by selling them, or you can have your own business. And then in return, you can have on royalties if you are licensing it. If you are selling it, you can have some money in return. Similarly, if you have a business, you can create money. So protection is granted for a limited period of 20 years. It's more than enough. Even if I talk about mobile communication technologies, they become obsolete in a span of 5 years. So to have a work protected for 20 years is a long enough time, because any technology becomes old within 10, 15 or 20, maximum of 20 years. So this is enough time provided by government to have a monopoly over your work, which is your invention. So for invention, technical work, for anything functional, you can have patents. You can have exclusive rights of patents to protect that work in your name. What government checks for when it provides patent certificate for any invention is that is your work novel? Is your work non-obvious? And is your work industrially applicable? There is a need to understand the definition of the three words, because the general definitions don't fit here. For if government checks about novelty, what do they mean is there shouldn't be any work in the prior arts. There shouldn't be any work before the date on which you apply for a patent, which is completely same as your work. There shouldn't be any such work. Globally, it is checked, not just in India. And if there is no such work, your work is novel. If you fulfill the criteria of novelty, the second thing checked is non-obviousness, or slash inventive step is checked. Both the terms mean the same. Now here what is checked is there shouldn't be any combination of works before the date on which you apply for a patent, that when you combine those two works, it becomes very obvious that your invention can be derived that way by any person who is just having average skill in your domain. What I mean is, if there is an invention in the prior arts which is A, there is another invention in the prior art which is B, maybe C or D also, and when you combine them, it's very obvious something is taken from A, something is taken from B, something is taken from C. It's just all mixed up, and even some things, some of the embodiments which are not in fact in A or B or C are very obvious to be included, because that is something people know from centuries. And it becomes very obvious that the combination of these two or three prior arts can be an obvious way of doing your invention. So it shouldn't be that case also. What indirectly it means is there should be some inventive step which you must have done on your own, which is not there in the prior art. There should be some improvement. The right word is improvement should be there, which is of your own. You are the creator of that improvement and not just picking up from different places. Thirdly, it should be industrial applicable. If it is of no use for an industry, it cannot be patented, because the agenda behind patenting is to commercialize, to increase business growth in India, to increase technology growth in India. And if it is not useful for the society, it's of no use. Invention without any use is of no use. So it should be industrially applicable also. Patents in everyday life. like by Edison and Swan electric lightning. These are very old patents, very well known patents, which are in your subconscious mind also. You know them. You have learned about them in your basic books of until 12th class. Sewing machine by Ho and Singer, iPhone, patents held by Apple, then magnetic resonance imaging patents held by Damadian. So these are very basic patents. Now we have so many patents. Multiple patents are filed in a day by Samsung, by Apple, by big companies like DRDO, DMRC. So you can go to Indian Patent Office website, patents website of the government, and check different patents which are filed daily. You will get to know, your mind will open that how companies, how researchers are working on different innovations. They are coming up with new innovations. Technology is growing so fast in India, and they are protecting it as a patent, which we never think of when we are in any institution or university. We don't think of it. So there is a need of awareness. Students, researchers do their research work, show it as a presentation in front of their teachers, and that's it. That's it. They pass out. Now we are into some job and like that. If they have done some good work, why don't you protect it? Why don't you create it? Create your own business out of it. If it is really a worth it, means why not to use that innovative work for your own benefit? Like on Shark Tank, you see so many works, so many startups have done that work or this work or that work. And if you really listen to that show, the sharks ask them that, do you have patents on this? Do you have a copyright on this? Do you have a design filed on this? They do ask it because they understand the importance. So there is a need of awareness. There is a need of awareness, and hence is this presentation. Second type of intellectual property rights is copyrights. Now, copyrights is for another category of inventors who are called creators. These are creators who are authors, artists who create some literary or artistic work. So here we are not talking about inventions. Inventors can protect their work through patents, and creators like authors and artists who do some literary and artistic work can protect their work using copyrights. If I talk about universities, their such specific works which can be protected by copyrights are some books which you may have written, some manuscript research paper which you have written, architectural works by Department of Architecture, then some drawings, maybe engineering drawings, or some databases which you may have created as a part of your research work, or some technical drawings, maps, maybe some questionnaire exam paper by a faculty or which may be created. So these types of works can be protected as copyrights. If I talk about a wider category of works, it includes novels, poems, plays, reference works, newspapers, advertisements, computer programs. How can I skip that? I'm sorry. Computer programs, which is line-to-line codings. Computer science department students do that. So that can be protected as copyrights. The functional aspect of programs, which talks about how it functionally works to help society, that can be protected as patents. But line-to-line coding in any language, particularly data processing, how it is done by coding, that is protected by copyrights. Then databases, also videographic works like films, and audio works like music, songs sung by anyone, lyrics, musical compositions, choreographic works, paintings, drawings, photographs, sculptures, architectures, maps, and technical drawings. All these categories artistic works, literary works, video works, musical works, sound recording works. All these categories can be protected by copyrights. And the protection is granted for a period of 50 to 60 years from the death of the owner. Just imagine the length of this time. It's almost lifetime. 50 to 60 years from the death of the creator. Means the whole family gets the benefit even if the person dies. So this is for literary and artistic works. And if it is the case of some film industry type of work like choreographic work or video work, artistic, some musical work or some song recording work, those works are protected for a period of 50 to 60 years depending on the country in which you protect it from the date on which it is published. It is made public. So that's a kind of lifetime duration. Now, what kind of works can be copyrighted? Literary, artistic, dramatic, recording works, and musical works. These 5 types of works. These types of 5 works are kind of protected by copyrights. And your inventions, I repeat it again and again, technical works are protected by patents. Then we come to another category which is popular amongst students and researchers these days is industrial designs. Popularly known amongst you all, maybe as far as I can imagine, is design patents, you may call it, but it's actually industrial designs, known as industrial designs in India. And in other countries like US, it is known as design patents. Now, industrial design refers to ornamental or aesthetic aspects of an article. How it looks to your eyes. Suppose mechanical engineering department has created some fabricated and designed and fabricated a product, maybe a funnel type of a product. If I just give you an example, the looks of that product, how it looks like when it's fabricated in your hands, how it looks like, that thing is protected by industrial designs. But the functionality of any product, the structural aspects and functional aspects, when written for any technological improvement, in a way of any technological improvement, that is protected by patents. How it helps, how it is that product is used, how that product is technical improvement over other products, that is a part of patents. But simple looks of that product, because that also gives you some market advantage. People buy a product just because of its looks, the how it looks like. There are Bluetooth speakers, but they are of different shapes. Functionality is same. Patent can be for the same technical work, but how it looks, that is a design patent, design patent or industrial designs. There are so many EV machines. Patent is one. The technology behind them is one. So patent held will be one. Improvements can be patented again and again, right? But the basic technology will be one only, in all the electrical vehicles. But the looks of different electrical vehicles of different brands will be different. Now that looks of any vehicle, there may be 10 different types of vehicles, 10 different types of cars, which Swift cars are different from Wagoner cars. Looks is different, no? So that looks is protected by design patents, so that the brand Swift cannot copy the design of car Wagoner. I just want you to understand this thing, that why we protect industrial designs, why we protect the looks as industrial designs. So design may consist of 3-dimensional features such as shapes, surface of an article, or 2-dimensional features such as patterns, lines, or curves. Design should be new, should be novel and non-functional. If it is functional, it is a functional aspect, then it will be patented. If it is non-functional and just the looks, it's design. So one product can be protected as multiple IPs also. It may be protected as a patent. It may be protected as a design for its design aspects. And if there is a coding behind it, that coding can be protected as a copyright also. There may be 3 IPs for one workers. So this is what is the relevance of designs. And designs are protected for a period of 10 years. Further, it can be extended for another 5 years, making a total of 15 years. So this is all about designs. Some designs you can look on the screen. Like Apple protects its shape of mobile phone, shape of laptops, also stuff, how it looks from the side, from front, from back. The shape, the looks is protected by design patents. The technology is protected by utility patents, which we discussed earlier, patents. The design is protected by designs, industrial designs protection. Then user interface icon shapes and icon looks is also protected by design patents. The coding behind it, that is protected by copyrights, and even the graphical user interface is protected by design patents. The whole graphical user interface, suppose in the second image you can see the screen, front screen, the look of that screen for that particular click when a person does, that is protected as a graphical user interface in designs, or it can be protected as copyrights also because there's some artistic work which is involved. So depends upon which IP is suitable for your business aspect, depending upon your concern. As attorneys, we suggest that which intellectual property right is suitable for your purpose. Similar is the design of a game or goggles or printers, and fashion designing industry uses industrial design protection so much. Whatever new design is created by Manish Malhotra or any other fashion designer, they do protect it as industrial designs so that other designers don't copy it and they can use that particular design of a dress for their own purposes, for selling and licensing and commercialization aspects. So this is all about designs. Coming next one, which is trademarks. Trademarks is a distinctive sign that identifies certain goods or services. Here, I just don't want to read it. I just want to simply say that if you have a brand, if you have a company, and in long term you envision it as a big brand known amongst the public, your company name, your company logo, your company's tagline, your company's tag sounds, all such stuff which recognizes your company as a brand, maybe shape or packaging even, or smell, sound, or taste even. Such things are protected by trademarks, maybe three-dimensional or two-dimensional. So distinguishing features, colored or maybe non-visible, which help you identify your goods or services as a company, as a brand, or as an individual. As an individual also, if I talk about a motivational speaker like Vivek Bandra, he's and motivational speaker for businesses. So, or maybe Sachin Tendulkar, he's a brand. His name is a brand. Such things are protected as, his name is even protected as trademarks. So, like companies like Coca-Cola, shape of the bottle of Coca-Cola cannot be copied by anyone. Such things are protected by trademarks. Company names are protected as trademarks. Company logos, Apple, the Eaten Apple logo. So such logos, whatever you can see on the screen right now, all this stuff is protected as trademarks so that identity of goods and services which is identified by a company can be protected and cannot be misused by others without their approval. So last two define that even shapes, two options define that even shapes can be used, can be protected as trademarks, like shapes of Coca-Cola, Fanta, Limca, Mirinda, Sprite bottles are all different, all protected as trademarks. Toblerone chocolate or Kit Kat, you can talk, all these chocolates are protected, shapes are protected as trademarks. If there is a logo which is having a name over it, also like Nike's logo, such are composite marks, these are also protected. Now there are some taglines like if I talk about Nirma, I think it's पहले इस्तेमाल करो फिर विश्वास करो. No, you say it's very normal, but these things, these lines are even protected as trademarks. Some sounds like ding, 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 ding. So even this small sounds, and even if I talk about Nokia or any other phone, they have some standard sounds when we just purchase them, and for calling ringtone sounds, standard sounds, which recognize their brand, their company name. All these sounds are protected as trademarks because these help you identify your brand. I think for Amul, there is a small girl with a ponytail, which they use for their branding purposes. That girl is also protected as trademark. I'll give you all the examples I'm able to recall right now. There are many, so many, but it's if you have understood this fact, then you understand what are trademarks meant for. Then, having discussed all these four, which were main patents, designs, copyrights, and trademarks, there are two other types of intellectual property rights, which are not that popularly known, but still are used. Okay, regarding trademarks, I missed to say that trademarks are protected for a period of 10 years. But before the lapse of the 10th year, you can apply again, reapply again for a further extension. And in this way, if you just further renew it after every 10 years, you can make it lifetime. You just have to pay a prescribed fees every 10 years, and it becomes protected for a, it can be protected for a lifetime. And similar is geographical indications. These are also protected for a period of 10 years and renewable. Every 10 years you can renew. But what it protects? It protects those goods which possess quality or reputation due to their place of origin. I just want to say this line, that all those products which possess some quality or they have some reputation due to their place of origin, due to their geography, they are protected as geographical indication. I would just like to straight away go to the example so that you understand this better. Oranges are known, but Nagpur oranges are famous. Those are geographical indications. Geographical indications. Petha is already known, very generic term. But Agra ka Petha, Agra Petha is a geographical indication. I hope all of you, when you go to Agra, you are always tempted to buy that petha from Agra because it has that quality, it has that reputation because of its place of origin. And that is the thing which is protected by geographical indications. So these are all the examples. If I talk about some international geographical indication, it's like Swiss watches from Switzerland. Watches from Switzerland are very popular. Very popularly known as watches from Switzerland, Swiss watches. Scotch whiskies from Scotland. And similar are other types of geographical indications. So you can see on the screen, when you go to Kanchipuram or Mysore, I heard, you cannot miss buying a product of silk from there. When you go to Darjeeling, you would always want to have so many samples of tea to keep it for yourself and to distribute it amongst your relatives. That this is tea from Darjeeling, Darjeeling tea, which is popularly known for its taste. So these are the things which are geographical indications. Protected as geographical indications. These are some which are already protected, and similar are others which you come up with something new like that, you can protect it. Then is trade secrets. See, trade secrets are intellectual property rights which protect your confidential information. As a business, if I talk about some businesses, they may be having some designs and drawings of computer programs or commercial information or advertisement information or distribution methods or list of suppliers or clients or advertisement strategies or pharmaceutical test data. some technical information, some strategic information, some commercial information which they don't want their competitors to know, which they don't want to in public, like Coca-Cola formula. You drink Coca-Cola, but you would never be able to know what is the formula behind Coca-Cola. What is the recipe of Coca-Cola? The formula is not known to anyone globally. This is a trade secret of that trade, which is Coca-Cola. They keep it secret through confidential agreements with their employees to whom it becomes really necessary to disclose the formula. So when through documentational work, through non-disclosure agreements or confidential agreements, you bound people to not disclose your information to others, which is important for you, which is kept as a secret. That type of protection is called trade secret. Here you have to ensure that you take necessary steps to keep it as a secret. If you don't take those necessary steps, here the responsibility is yours and not any legal certificate is provided. This cannot be protected. But this is protected through legal documentational work. Plus, you have to take all the necessary steps to keep it as a secret. Moreover, if someone comes up with the same work as yours through their own R&D or through reverse engineering or through market analysis, and that someone obtains a patent over it, then we lose that trade secret. It's a secret until it is not opened up by others or not disclosed to others. So if someone comes up with the same secret as yours on their own, or if it is disclosed even, whatever may be the uh, uh, injunctive reliefs that person has to pay back to you because of the documentational work. But still, if it is disclosed, then it is disclosed. It's disclosed. It is no more a secret. So, some examples I would like to give to you that Coca-Cola, Listerine, these are protected as trade secrets. No one knows their formula. WD-40, no one in the globally knows their formula. Protected very, very strategically by their companies. Google algorithm, no one knows how Google works, what is the algorithm behind it, no one knows. And it's the one of the most popularly known uh, uh, search engine. And the algorithm of which is not known to anyone. It's not patented. It is not patented. Because the company feels that they have a competitive advantage in keeping it secret rather than protecting it as a patent, which they may or may not get, because software completely purely software inventions cannot be patented in India unless they have some hardware or they can produce some tangible product using that software, or they provide some technical advancement. Until that is the case, they cannot be protected as patents. Similar is the case with KFC fried chicken, and similar is the case with McDonald's Mac special sauce and their burgers, that these are also trade secret. Recipes. Recipes like these are also trade secrets. Lastly, importance of IPR in research and innovation. Importance, I think we have discussed in the outset also, but yes, keeping your ideas safe. Your ideas, keep them safe. Have an IPR protection over them. Own them. Have monopoly over them, because this is what you have done. Use it for your own benefits. Keep your ideas safe. Importance of IPR. Second, protect business growth. Business can only grow when it comes out of competition. When you have a patent or a copyright or trademark, when you protect your work through IPR, you get a monopoly for another 20 years or similar periods. That monopoly protects your business because you grow your business. While you grow your business, your competitors cannot grow using your same product because you have owned it as a legal property. So it protects your business growth. Commercialization benefits. Okay, you may think that I don't want to have a business. I'm not such a person. I want to do job. Commercial benefits other than business are also there through IPR. You can license it to manufacturing firms or other companies who can sell it on your behalf, and in return you can get royalties for each product being sold or monthly royalties when you license it to other companies. You can, another way is you can sell it to other companies and you can get a big amount in return, one time amount in return, that is selling your IP once you own that IP. These are commercial benefits. And last is it spurs economic growth and competitiveness. When you invent something, others are motivated, others are inspired, do the same to do more improvements by reading your work, to grow economically, to grow the technology over the work which you have done by making some improvements. So it increases economic growth by increasing competitiveness. That's all for the day. Thank you so much. It was a great day, and I would like to have some questions. If anyone is having some questions, they can definitely ask me. And this is all from my side. I hope I have made it very clear that what is IP, what are intellectual property rights, types, and importance of IP. Thank you so much. Yes, ma'am.
Certainly, ma'am. Thank you. It was a very informative session. The house is now open for questions, if any. Your mics have been enabled. So anybody who would like to ask a question is welcome.
Hello, ma'am, may I audible?
Yes, sir. Yes, sir. You are. Please go ahead.
Yes, please.
Yes,
Please ask.
actually, this was really, ma'am, wonderful session. So you enlightened all of us by differentiating what is patent, what is geographical indication, and what is trademark design. Can we copy the Coca-Cola trademark of bottle or color? Correct. That was really amazing, especially for us and for our student as well. And secondly, ma'am, my question is that like I have certain model I'm working on the improvement of MSME, I mean small medium enterprises. So in this regard, certain paper have also been published. So can I go for patent for a model, ma'am? So like I prepare one model and I prove it statistically or uh, through convolution neural network. So can I go for patent for such kind of model?
See, there is a need to understand at least a brief summary of your model, because there is a need to understand under which category it can be protected. As far as I'm able to understand, it can be either protected as patents or copyrights. If it is purely software kind of an invention without any tangible product in it, or which is not having any technical advancement but a mere data processing kind of a framework, that is protected by copyrights. But because the coding behind it can be protected as a copyright, but if it gives some technical advancement also, uh,
Mhm.
and it can be, dumped into some hardware product which can be sold in industry as a commercial product also. If that is a kind of a case, it can be protected as patents. Plus, second concern here is you have already published a research paper on that. There is a need to understand this fact that when we do some research work, which is, I think, researchers don't have awareness of, is that firstly you should file it as a patent and then you should apply for it as a research publication, because your work, although it is in your name, your research paper can be used by examiners sitting in the patent office as a prior art. They will not understand the fact that the work is yours, the author is same. They just understand the fact that it is already there in the market and in the form of a publication, or even it can be on Facebook or any other social media, even or even in newspaper also. They can use those clips of videos or any document which is already published anywhere. They can use it as a brand, even if it is in your name or not. There are some ways of getting it patented if you file the patent in a span of 1 year, but that too is complicated and always avoided. When you do some research work, keep it confidential until you file it as a patent. Once you just file it, just you apply it as a patent, then you can apply as a research paper, because research papers, publishers don't impose such kind of problems. But in patents, examiners do pose. They make it problematic for researchers to have patents once they have already filed it as research papers. So that should be first public disclosure, which should be patents. Then you can apply it as a research paper. You can get a research paper also, which is published, and you can get a patent also, which is granted. Both benefits can be availed, but we should understand the fact what is to be applied first. This is awareness. This is for all the researchers out here who are listening to me. I hope I have clarified your point, sir.
Yes, I do agree with that. And another thing is that there is a big difference between patent publication and patent granted.
Yes.
I
Yes.
mean, yes, publication is quite easy. I mean, you have any new idea, you can submit it, you can pay fee. What is your opinion? What is the special thing that make the patent from published to granted? Because I observed like a lot of people having patent published, but they don't have granted. So what is the unique thing that make the journey comfortable from publication to granted?
See, for publication, now the point is that you should have all the forms and everything uh, in order. That's it. But when it comes to grant, there are so many things, so many pointers which are analyzed by examiners. The main analysis, the main examination happens when you apply a request, when you file a request for examination for grant. There, the time, it takes time also, and there is no guarantee it will be granted or not. I would like to come to the slide on which I was trying to make you aware of the fact that when can it be granted. So what kind of inventions qualify for patentability? By patentability, I mean patent grant here. Firstly, try to understand there are a few inventions which are totally cannot be granted, just like computer software inventions. Simple coding programs, they cannot be grant, they are not granted patent in India. This is a fact which you have to understand, except from even though you are from EC department or computer science department, that I come up with so many inventions. We are working with so many institutes and universities. They do some data processing work, which is through artificial intelligence or machine learning. Purely software based computers. Yes. On the computer screen that work is done. But such works are very difficult to get patent over, because though that work is real, though that maybe that work is novel also, but that work doesn't come under the realm of patent protection in India. Such works can only be copyrighted in India. But if that same work that can be burned into a hardware which can be used for commercial purposes as a product, which is inventive, which is having some improvement of the over the works which has already been done, which have already been done, having some economic value, having some technical advancements, the same work which is done by AI or ML. But if that can be that work can be used in some model, some system, some hardware which can be sold in the market, then that work can be patented. You have to analyze your work in terms of three criterias: that it should not be anywhere globally same, there shouldn't be any work globally which is same as yours. This is not the search done in India, but this search is done globally. Even if someone sitting in New Zealand has done same work as yours, as an inventor, we don't do that much research. Go to Google Scholar, do all the research of all the publications done so far, do the research of all patents which have been published so far on patents.google.com. Similarly, you can go on, scholar.googles.com. I think it's for publications, and for patents, it is patents.google.com. Go to that website, search for novelty of your work, search for inventive step in your works. Just check if there is, through keywords, you can write the major keywords and features of your invention. There shouldn't be any case like 2 or 3 works are combined together and it becomes obvious for a person to come up with your work. Plus, it should be industrially applicable also. These 3 criteria, apart from the works which are completely excluded from patentability, like mere computer programs and compositions, formulas of medicines, medicinal formulas, which are there, and they do not provide any efficiency in terms of therapeutic efficiency, but these are same compositions and different formulas for same compositions. Such kinds of things are not granted patent in India. So you have to analyze your work, and you have to check your work that does it really fall under the criteria of those works which are not patented in India. So you have to check that work very skeptically you have to check this. Thank you, sir.
Sir, you are on mute mode. Manish sir, you were mute.
Yes.
Yeah.
Thank you, madam. It makes sense. Thank you for this.
Thank you. Yeah. If anybody else would like to ask, you may please ask your question now. All right. Am I audible? Yeah.
Yes,
Dr.
ma'am. Yes.
Tuliga,
Yes, ma'am.
Yes, sir, please.
Dr. Tuliga, you are having 4 or 5 patents, no? You might be having some queries.
Yeah. Yes, sir. I have some patents, but these are that patents are Australian innovation patents. These are not Indian patent.
Now you
But
ask
I
ma'am how
want
to
to actually,
commercialize that. How to
Yeah.
convert this one? This you have applied. But how to receive the patent? What's the formula? I think she will let you know.
Yes, yes. It's a very good question, sir. Yes, ma'am. Actually, I have patents on herbal product. Means I have isolated some compounds from indigenous medicinal plant, and that compounds are novel compounds. It's first time isolated by me only, and I have patented that compounds as Australian innovation patent. As that patent usually takes short time. For that reason, in case of Indian patent, it will take long time. But how do I commercialize that product? I certainly want to know from you.
Yeah, see, I have heard of Australian innovation patents, and we have got them for our clients also. See, for Australian innovation patents, if you want to think about commercialization, now here you have got that innovation patent, but if you think about commercialization, since you have got a patent in Australia, you can commercialize it in Australia only. You have to accept this fact because patent rights are territorial in nature. So wherever you get that right, you can commercialize in that particular jurisdiction only. Secondly, in Australia, even though you get Australian innovation patent, you have to get it certified first. Certification document is required, which takes another 1 to 2 years time. You need to get in touch with your attorney for that, which is Australian attorney. Once you get a certificate document, then that document can help you in commercialization. So actually, it's a confusion that doesn't take much time. In all the jurisdictions, it takes almost 2 to 3 years of time. But we get a little bit confused because we are not aware about the legal aspects of different countries. So that your attorney will explain you in more explanation that what exactly is the process before you start commercialization. As a part of your commercialization, you have three different ways. Either you can create a business, but since you are in a job, you would not prefer that. So other type ways to commercialize your invention are to license it to some manufacturers or companies in Australia. They can sell your invention if it is a product market fit kind of a work that market will also would like to have. It's not just product is good, but it should be usable for the market also. Na market should also, you have to make it product market fit. Maybe you require some modifications or improvements like that. So once it is product market fit, then you can license it to some companies who can sell it on your behalf. While you are into job, you cannot do that. So for every product being sold, you can be given royalties. That is technology transfer which you do, and for that you will get, for every piece of product being sold, you will get royalties. That can be 10%, 20%, 50%, or whatever is mutually decided through agreements. This is one way. Another way is to simply sell it. Simply transfer the technology to another company, and in one time you get a big amount if they really want to purchase it. There are so many things involved here. You need to discuss with so many companies, shortlist 2 or 3 who are interested in your product, and then either sell it or license it. These are the two ways for a person who is in job and who doesn't want to create a business. So very good options. That's why patents are called a type of passive income also. So side by side you can earn out of it. I hope it is clear, ma'am.
Thank you very much, but it will take long time.
Yeah,
As you have
definitely.
explained.
Yeah, you have to do this very strategically, and you have to take some time out of your busy schedule.
And I have to, first of all, I have to actually contact with one attorney who can
Yeah.
actually deal all these things.
Definitely.
Thank you
definitely.
thank you very much, ma'am, for this information.
Thank you so much. Thank you so much. And in fact, to SPSU, I just hope they are in link with some attorney, or I should otherwise motivate you or be, do some work, do some meetings in this regard, that all the students and researchers and faculties who are doing some research works, who have good labs, you should be in touch with attorneys for such aspects, IPR, patenting, and that should be that maybe in the name of institute also, university also, SPSU also. SPSU, just like I was telling to Tulika ma'am, they can also do their technology transfers. Whatever inventions, whatever products, whatever their work, students and researchers have done the work, 50% can be in the name of the faculty, 50% can be in the name of the institute. And institute, for whatever good products are being created and patented, they can do transfer of those works to different companies and on royalties. 50% can go to faculties, 50% can go to institution. That can be decided mutually, but there should be a link with an attorney to firstly file patents, file designs, file copyrights, so that in future, as a university, you can also grow with the help of technology transfer, which is a good way of passive income for the university also. Yeah.
Yeah. Next question, please.
Vipsarana.
Yes. Good afternoon, ma'am.
Good afternoon, sir.
See, many beginners came to me and they always ask that whether we should go for a consultant for IPR or they can do it by your own. So, what is your view in this?
See, if you want to go up to grant, never do this on your own. Always have advice from an attorney, because this is a skill acquired over a span of 10 to 15 years. As a profession, as a person in job, we are more into research and teaching. you as faculties. So you don't have that mindset, that skill which is required for getting grant over patents. That's a different skill and different industry, requires not only technical but also legal knowledge.
Okay.
So if you really think that you have to only apply and it's okay, let's take a chance by saying spending some government fees, then you can do it on your own. But if you are really serious and you want to have that certificate, go through professionals, go through some consulting firm, because this is what I have faced. Because we are into this industry, we help inventors. Those who file on their own, they end up in spending more money because they don't know the skill, and at last they go to consultants only for the works they have already filed.
Mhm.
So it's better to in the outset itself, as a university, either SPSU can help by linking up with some firm. We are also in link with so many universities, or you can personally get in touch with a consultant and then do that yourself personally.
Sure, thank you.
Thank you so much.
Do we have any more questions? Anybody else has a question to ask, ma'am?
You are providing the handholding for these students. If suppose they are coming out with some of these ideas, because ideas also can be patented or process also can be patented, or
See,
product design also can be patented.
yes,
So
everything can be patented if you have all the details of working construction with you. If you can provide all the details which are required for implementation of that idea, specification details, working construction details, drawings, then that can be filed as a patent. Because the concept is in your idea, maybe that requires a lot of investment to be made physical, to be implemented. But still, if you know every this and that of doing that, every information, working construction drawings, objectives, and the whole way of doing it, problem solving, then that can be patented. And we do provide hand holding because this is what we do. This is our day and night work. We are in collaboration with many universities also, like ATME, and in South we have Rathinam Institute and so many institutes. It's difficult to tell all the names. And we provide hand holding to individual inventors also from different universities and institutions. Individual researchers are also in link with us, plus university collaborations are also there with us, wherein we are provided multiple works from different departments, and we provide the assistance on just checking under which type of IPR the work falls into, and then providing them assistance in filing, publishing, and granting that particular type of IP. Preferably, especially patents, because that increases your accreditation value as a university also. It is very helpful in NAC, NIRF, and NB, and all other accreditations. Government is motivating so much. Atal Innovation Mission, ICC, I think this webinar is also from that associations. All these associations are motivating now. Government fees is also made 1/5 just to motivate universities to file more and more patents. Earlier it was 8,000 what government fees I'm telling, but now it is 1,600 only per patent filing. Almost decreased 1/5. And I think SPSU is a very brand name, which is by JK Cement. And
for
it's
one particular patent, ma'am, how much is the charge, if you don't mind?
the
Approximately, just.
government
Nay,
fees is
for
1,600.
helping the students till the time of like your execution and got the patent for a single patent.
For a single patent, sir, the minimum fees which you can see in the industry right now for whole filing, form preparation, drafting of the whole document, drawing, professional drawing preparation, and everything involved, which takes almost a month, is 25,000, which is minimum fees I've seen. When two or more inventors can join up their names, they can distribute amongst them. They can divide that amongst them. The minimum fees which is seen in the industry, I'm very talking about all the firms I know, is 25,000 minimum. Maximum is more for corporates, but I think for institutions it is 25,000. But if we talk about universities, and some multiple filings are there, so that can be worked out for any discounts which may be available, like that.
Thank you so much, ma'am. Thank you so much
Thank you, sir.
for addressing our students and our faculty members. Even if we also got some idea about the differentiation of the copyright, trademark, patent, and so many other things also you have mentioned. About starting from the like the patent filing till the commercialization of this patent, and that's a very good thing. And on behalf of the SPSU and on behalf of our Vice Chancellor and the President, Professor Dr. Padmakali Banerjee, I would like to thank you that for spending your valuable time and addressing to our faculty members and the students, and also the participants from outside our institute. Okay, so thanks a lot.
Thank
Okay,
you so
thank you. Thank you so much. Thank you
Thank
so
you.
much.
Thank you very
Thank you.
much, ma'am.
It was
Thank
an honor for me to be a part of this conversation, and I'm really happy that all of you have interacted so much. There
Yes,
were so
yes.
many questions, and that really makes me happy, because if you have understood, that's why you are asking questions, and that makes my day. Thank you so much.
Thank
you
you.
very much.
Most certainly, ma'am. Most certainly, your insights, the ideas, and the elegance of explanation has actually, made this session a remarkable one. And I'm sure the audience has are high on the content quotient, because they have much to take away from this session. Thank you so much for sparing your time for us. Thank you.
Thank you so
Thank you,
much.
ma'am.
With this, I
Thank
take
you.
the leave.
Yeah.
Thank
Thank
you.
you so much, ma'am. It was a pleasure having you. Thank you.
Yes, yes, please.
Bye now.
Thank you.
Thank you.
Okay, thank you. Thank you.
Thank you, Disha, ma'am. Now I'm leaving.
Thank you. Thank you, all the participants. Thank you very much.
Okay, bye. See you.
Bye.
Thank you, ma'am.
Yes. All right.
Thank you.